Hello everyone, welcome to IAS Baba's Rapid Revision Series for Prelims 2022. This is day 38 and we take up polity. So emergency and other topics we are discussing here. First one, approval, removal and revocation of Article 352. So under Article 352, the President can declare a national emergency when the security of India or a part of it is threatened by either war, external aggression or armed rebellion. So these 3 points will become important. And then the parliamentary approval. The proclamation must be approved within 1 month from the date of its issue. So for Article 352, it is 1 month and the approval is through special majority, not through simple ones. So 2/3 majority, that is present and voting. Then if Lok Sabha has been dissolved during the period of 1 month, then the proclamation survives until 30 days from the first sitting of Lok Sabha. So the Lok Sabha, after its first sitting, within 30 days, it has to approve. Then the renewal. If approved, emergency continues for 6 months and can be extended to an indefinite period with an approval for every 6 months. So for every 6 months, the approval is required for the continuation. Then the resolution approving the emergency or its continuance must be passed by a special majority. So again, even for the continuance, we require a special majority. Then revocation of proclamation, how to revoke? By the President at any time by a subsequent proclamation. And such proclamation does not require a parliamentary approval. So it is very easy to revoke an emergency, but it is very difficult to approve or renew an emergency. And if Lok Sabha passes a resolution by a simple majority disapproving its continuation, so either of things, they can revoke the proclamation of an emergency. Then come to next, the approval, renewal and revocation of Article 356, that is the presidential rule. So the president rule can be proclaimed if president is satisfied that government of the state cannot be carried on as per the provisions of the constitution. So we can say that failure of the constitution can be one of the causes for proclamation of the Article 356. Then as per Article 365, so whenever a state fails to comply or if it fails to implement the direction given from the center, and then parliamentary approval of Article 356. So that should be approved by both the houses of the parliament within 2 months through a simple majority. So here it is simple majority. And then, however, if Lok Sabha has been dissolved, the proclamation survives until 30 days. Here it is same, that is 30 days. Within that, Lok Sabha should approve. Then the renewal. President rule is initially for a period of 6 months and it can be extended for a period of 3 years within the parliamentary approval every 6 months. So here every 6 months we can renew, but the maximum limit is 3 years. And the 44th amendment said that President's rule cannot be extended beyond 1 year unless there is a national emergency in India in action or the Election Commission of India certifies that it is necessary to continue the President's rule. So if Election Commission says that it is difficult right now in that state to conduct an election, so only then it can be extended beyond 1 year. So however, in any case, the maximum limit is 3 years only. Then revocation of President's rule. So President's rule can be revoked anytime by a subsequent proclamation by the President. Then a proclamation of revocation does not require approval by the Parliament. So again, here also the revocation is easy and the proclamation and renewal has been made difficult. Then the status of fundamental rights during emergency. So Article 358 says suspension of fundamental rights under Article 19. That is, during the national emergency, the 6 fundamental rights under Article 19 are automatically suspended. And Article 19 is automatically revived after the expiry of emergency. Then, the 44th Amendment said that Article 19 can be suspended only when national emergency is late due to war or external aggression and not in the case of armed rebellion. So, in case of armed rebellion, Article 19 cannot be suspended. Then come to next, Article 359, it says that suspension of other fundamental rights. So what are those? President is authorized to suspend by order the right to move any court for the enforcement of fundamental rights. So that means the remedial measures are suspended, not the fundamental rights per se. So fundamental rights, they remain in the constitution intact. But the thing is that we cannot enforce it through the court of law if there is any violation. Then only those fundamental rights are suspended that are specified in the presidential order. So President in this emergency proclamation, he can mention that what are the fundamental rights can be suspended and only those shall be suspended. Then the suspension could be for the period during the operation of emergency or for a shorter period. President can also mention that the fundamental rights need not be suspended throughout the entire period of emergency. It can be suspended only for a shorter period of time. Then the order should be laid before each house of the parliament for approval. And 44th Amendment Act says President cannot suspend Article 20 and 21. So these two articles cannot be suspended immaterial of which emergency you bring in. So these are some of the facts for suspension of fundamental rights during emergency. Then the subordinate courts. Friends, we all know that Supreme Court, it stands at the helm, and then comes the High Court and then the district courts. And after district courts, we have the civil and criminal court being segregated. So below civil court, we have the court of civil judge and the court of munsif. So remember, munsif means a civil court. And then below criminal court, we have the court of session judge, then the court of chief judicial magistrate, then the first class judicial magistrate and the second class judicial magistrate. So friends, here it is not just remembering, but the thing is that, so whenever we go to the lower courts, so here the difference between the executive and judiciary is not clearly demarcated. So most of the times our panchayat development officers, our tehsildars, so they also look into the judicial cases. So however, these things are different in different states. So that is why crudely if you remember, so that is more than sufficient here. Then the structure of the jurisdiction. The district judge is the highest judicial authority in the district, and he possesses original and appellate jurisdiction in both civil and criminal cases. So he is the only judge in these lower courts who can hear both civil and criminal cases. After him, the segregation occurs. Then the criminal matters. So district judge is known as the session judge when he deals with the criminal matters, and when he hears a civil matter, so district judge is known as a district judge only. And then the district judge exercises both judicial and administrative powers. So here this statement means that the administration of court is also looked after by the district judge. And previously, the district magistrate himself, he used to look into some of the civil cases, but now that has been removed from his jurisdiction. Then he also has supervisory powers over all the subordinate courts. So being the senior most judge, he can supervise and inspect the subordinate courts. Then appeals against his orders and judgments lie to the High Court, and the sessions judge has the power to impose any sentence including the life imprisonment and the capital punishments. So he can also impose a capital punishment. So a point to be remembered. Then come to next. The appointment of district judge in a state are made by the governor of the state in consultation with the High Court. And the qualification criteria, it should not already be in the service of the center of the state. There is no office of profit, and he should have been an advocate for 7 years. So this is the criteria for becoming a district judge. So these are some of the facts. Then come to next. Special leave and curative petitions. First one, the special leave petition. Special leave to the appeal is filed before the Supreme Court under Article 136 of the Constitution. It means that Supreme Court is authorizing to grant in its discretion special leave to appeal from any judgment in any matter passed by any quota tribunal in the territory of India, except the military tribunal or the court martial. So mark these two exceptions as important ones. And then special leave petition is not an appeal, but a petition filed for an appeal, and the Supreme Court may accept or reject the same. So here it is not an appeal, but it is like a special leave, a special permission given so that they can re-petition the case that has already been resolved. Okay, so this is special leave petition. And after special leave petition, we have one more, that is curative petition. Curative petition is the final and the last option available to the people for seeking justice in the framework of the judiciary. Then its objectives are of two folds. One is to avoid miscarriage of justice and to prevent abuse of process. So in these cases, so even in the last moment, the Supreme Court will take up the case for one more time. And this is supported by Article 137 of the Indian Constitution. Then, under Article 145, Supreme Court has the power to review any judgment pronounced by it. And such a petition needs to be filed within 30 days from the date of judgment or the order. So such restrictions are made only to make sure that many curative petitions will not clog the Supreme Court. Then, it can be entertained in case of violation of principles of natural justice. Then, the curative petition must be dealing with a case that is rare rather than a regular case. So here we can say that once we finish all our appeals, we are left with two. One is the special leave petition, and after that the curative petition. Curative petition is the last resort. After that, we don't get any chance to appeal or petition. Then come to next, the rule of law versus rule by law. Friends, this is a conceptual one. So rule of law means it is the rule of the law of the land. Say for example, Indian constitutional philosophy. So that is the law of the land. So Indian preamble, secularism, then socialism. So these are the rule of the laws on which all other laws have to be based on. Say, for example, the unity and integrity of the nation or sovereignty of the nation. So, when we take that case, so once a case arose wherein Jayalalitha, the former Chief Minister of Tamil Nadu, so she was dismissed by the Election Commission from contesting an election. But however, her party won the majority. So now there arose a conflict, that is whether the Election Commission's disqualification stands or whether the voice of the people, which is considered as the law of the land, whether that should consider. So now the Supreme Court said the law of the land is the law of the whole India. So it is the law of the constitution which is adumbrated in that, and it is not the law of Tamil Nadu land. So that is why Jayalalitha was not allowed to take up the CM's post. So this is how the rule of law means. And then the rule by law. So rule by law means, so law is the paramount. So if I pass a law, even it is unethical, so I can go ahead with that. So here we can say that the Britishers used rule by law rather than rule of law in India. So they passed illegal laws and they implemented that with utmost inhumanity and ignobility. And then even the Nazi Germans, so they passed illegal laws and they implemented that. Say for example, the concentration camps and others. So these are some of the differences between the rule of law and rule by law. Then come to next, the court's power to punish for contempt. So here we have two types of contempts. One is the civil contempt and the other is the criminal contempt. So here, civil contempt is a willful disobedience to any judgment. So if you are willfully disobeying, it is a civil contempt. And then we have criminal contempt, that is the publication of any matter or an act that scandalizes or tends to lower the authority of the court. So that means if I demean or disfigure the authority of the court, or if someone prejudices or interferes or tends to interfere with the due course of any judicial proceedings, or if he interferes or obstructs the administration of justice in any other manner. So that means if someone is trying to halt the implementation of the judgment of a court, or if someone tries to halt the hearing and administration of the court, so that is also criminal contempt. Then Article 129 and 215 of the Constitution empowers the Supreme Court and the High Court respectively to punish for contempt. So remember these two articles. Then come to next. The Contempt of Court Act 1971 defines the power of High Court to punish contempts of its subordinate courts. So this power of High Court is not written in the Constitution, it is written in this Act. And then the Constitution also includes contempt of court as a reasonable restriction to Article 19. So it is one of the reasonable restrictions for freedom of speech. Then a contempt of court can be punished with simple imprisonment for a term which may be extended to 6 months, or with fine which may be extended to 2,000 rupees, or with both. So 6 months or 2 months of imprisonment, or both. So these are the punishments for the contempt of court cases. Then come to next, the mediation bill. So mediation settlements agreement has been made enforceable by law, and here the challenge to the mediation settlement agreement so has been permitted on limited grounds. So that means, so if some mediation has happened and on some grounds, so they can appeal that mediation in the higher courts. So usually mediation happens with the consent of both the parties. So there are least chances of disputes arising from these. But however, if in any case the dispute arises, so here the MSA can be challenged in the court of law. Then the mediation process protects the confidentiality of the mediation undertaken. So the mediation is kept confidential. Then also it approves for immunity in certain cases against its disclosure. So in some cases the mediation can also be disclosed. And then the registration of the mediation settlement agreement has also been provided for with the state, district and taluk legal authorities within 90 days to ensure the maintenance of authenticated records of the settlement so arrived. So that means if a mediation has arrived, so within 90 days it has to be recorded by the concerned authority at the concerned level. Then the law provides for the establishment of the Mediation Council of India. Then it provides for the community mediation. So the mediation agreement can involve the whole community also. So recently we are going to enact this mediation bill. If that comes into effect, so all these provisions will be available. So remember these facts regarding the mediation bill. Then come to next, the national litigation policy. So here the new government had proposed a national litigation policy for the out of the court settlement of cases among the government departments and public sector undertakings and other government bodies. So instead of clogging the court again and again, so out of the court settlement, so that would be feasible. Then the government litigation reportedly constitutes nearly half or all of the litigation in the Indian judiciary. So we know that the government is the largest litigant and it acts as a constraint on the public exchequer. So many times the projects are stayed and injunction orders are given for any project. So all these will hurt the funds. And the government's litigation also contributes to the judicial backlog. So to avoid all these things, the national litigation policy that gives the opportunity for out of the court settlement. Then come to next, the SUVAAS and FASTER. So what is SUVAAS scheme? It is the Supreme Court Vidik Anuvad software. So that means Anuvad, the translation. And it is a machine assisted translation tool trained by artificial intelligence. So mark this as important. Then this tool is specially designed for the judicial domain and at present has the capacity and capability of translating English judicial documents, orders or judgments into 9 vernacular language scripts and vice versa. So as of now, it can translate English orders into 9 other regional languages. Then this is the first step towards introduction of artificial intelligence in the judicial domain. So along with that, we also have the SUPAAS. So that we discussed already. So remember SUPAAS with SUVAAS. Then FASTER. The Supreme Court has introduced the fast and secure transmission of electronic records system. So this one is used to circulate the records in a speedy manner. And through this system, Supreme Court's crucial decisions, including orders on the bail and stay of arrest, can be communicated electronically to prison authorities and investigating agencies through a secure channel. So whenever the order has to be passed on to different authorities, so now it goes through the mail or through any electronic media rather than going via physical media, which is always time consuming. Then the rules and handbook on practice and procedure of Supreme Court enables the transmission of certified copy of judgment or order either in the physical or electronic form. So now we are using the electronic form. So these are the SUVAAS and FASTER. Then the National Courts of Appeal. The Chief Justice of India has urged for the National Courts of Appeal and the National Court of Appeal will have regional benches in Chennai, Mumbai and Kolkata. Then it is meant to act as a final court of justice in dealing with appeals from the high courts and tribunals in civil, criminal, labor and revenue matters. So any kind of appeal. So people instead of traveling long way from different regions of the nation to Delhi, so they can file their complaints in the regional benches. Then the Supreme Court of India situated in Delhi would only hear the matters of constitutional law and the public law. So only important laws will be taken up by the Delhi bench. Then as of now, all appeals have to be heard in New Delhi, which is inconvenient for the cases originating in the other parts of the country. So traveling is a major issue, especially for the middle class and the lower middle class. Then if there are areas of law that are particularly unsettled and need clarification, then the Court of Appeal can club them together and forward to the Supreme Court. So if 4 to 5 cases which are similar, they can club and they can allow the Delhi bench to adjudicate on that. So even here, we can save the human resource and time. So this is all about the National Courts of Appeal and we update in future if there are any steps taken regarding the same. Then come to next, the Vanniyar quota. So the Tamil Nadu government has filed an appeal in Supreme Court challenging the Madras High Court's order, and the order had declared ultra vires, a law of Tamil Nadu government which provided 10.5% of internal reservations for 1 year within the overall 20% quota for the most backward classes. And here the reservation was made in commensurate with the population as enumerated in the survey held in 1983 by the Tamil Nadu Second Backward Class Commission. So they did it with a proper survey. And here the Vanniyars are one of the largest and the most consolidated backward communities in Tamil Nadu. And due to their backwardness, they had raised massive protest in mid-1980s demanding 20% reservation in state and 2% in the central services. And during the agitation in 1987, many protesters were also killed. So here, the split of the quota OBC quota occurred. That is, in 1989, OBC quota was split into two. That is, the backward caste and the most backward castes. And Vanniyars were categorized among the most backward castes with 107 of their communities. So thereby grabbing a place within this 20% of reservation which was allotted for the most backward castes. And 3 decades later, the state government passed a bill and the current government has implemented it with a government order ensuring 10.5% of reservation for Vanniyars within the 20% of the most backward caste quota. So this is a brief account on the Vanniyar quota case which is going on in the Supreme Court. Then come to next, the NCLT and ITAT. So NCLT means it is the National Company Law Tribunal and we have an appellate tribunal for that, that is the National Company Law Appellate Tribunal. And here the NCLAT was constituted under the Section 410 of the Companies Act. So remember the act under which it was being created to hear the appeals against the order of the National Company Law Tribunal. And the NCLT is a quasi-judicial body that adjudicates the issues related to companies. And it also receives appeals under the Section 61 of the Insolvency and Bankruptcy Code, and for the orders passed by the Insolvency and Bankruptcy Board of India under Section 102. So that means, friends, it is any matters related to the company. So even the bankruptcy is a matter related to company. So thereby, even these cases, it can take up and adjudicate. Then, any person aggrieved by any order of the NCLAT may file an appeal to the Supreme Court. So there is an appeal available over and above the NCLAT to the Supreme Court. Then come to next, the ITAT, that is the Income Tax Appellate Tribunal. So it is a quasi-judicial institution set up in 1941 under the Section 5A of the Income Tax Act 1922. So remember the act under which it was created. Then presently ITAT has 63 benches and 27 different stations. So it is widely present all over India, and it deals with appeals under the Direct Taxes Acts, namely the Income Tax Act 1961. So it deals with the direct tax, not with the indirect tax. So we have the GST tribunals for the indirect taxes. And then the order passed by the ITAT are final, and an appeal lies to the High Court only if the substantial question of law arises for the determination. So only appeals for the High Court in exceptional cases are allowed for this ITAT. Then come to next, the Tribunal Reforms Act and the Rules 2021. So the Tribunal Reforms Act absolves certain appellate tribunals and boards and shifts their function to the other existing judicial bodies such as high courts. So this was an attempt to rationalize the tribunals. There were a number of tribunals that were established, and there was so much of overlap and confusion that was going on. So that is why many tribunals were abolished and their jurisdictions were transferred to the others. That is, it seeks to abolish the Film Certificate Appellate Tribunal and then the Airports Appellate Tribunal, etc., and also brings in changes in the terms of service of the tribunal officials. That is, the search cum selection committees will be constituted, and on the basis of the recommendations of these committees, the central government would appoint the chairpersons and the members of various tribunals. So now there is no arbitrary appointment, only on the basis of the recommendations of the search and selection committee. So there is an attempt to rationalize the appointment procedure and make it transparent. Then the government should act upon the recommendations preferably within 3 months. So a timeline is also given so that government will not sit on the cases. Then coming to more facts, the Act provides for 4 years of tenure. So a definite tenure is being fixed so that the officials are not transferred arbitrarily. Then the Finance Act of 2017 had merged the tribunals based on domains, and it also gave powers to the central government to notify rules on the composition of search cum selection committees, and then tribunal members' qualifications, terms and conditions of services like salary, removal, etc. So that means, so whatever clauses that were contemplated to be added inside this Tribunal Reforms Act, so they were already added with the Finance Act. But however, this Finance Act is a financial bill. It is not an ordinary bill. And there is a claimer going on that the center is camouflaging several ordinary bills in the name of financial bills or the money bills, so that they can bypass Rajya Sabha. So to avoid that allegations, so now the clauses which were present in the Finance Act were removed, and now they were put into the original Act. And then the new Tribunal Reforms Act removes these provisions from the Finance Act and it embeds them into its own Act. Then the new Act also makes amendments to the Consumer Protection Act. So there were many changes made to the consumer tribunals and others. So these are some of the facts. Then come to the last part. Friends, once we make up our minds to achieve something or to accomplish something, so no matter how many hurdles come, so no matter how many hindrances come, so our brain and heart and body, so they all will fight against, so that we will accomplish the dream to the best possible extent. So no hindrances can stop a brain and body that is committed to achieve something. So that is what we say when we speak about the man with a vision and a mission. So Mahatma Gandhi ji had a vision that I will take my India to this position, and he strived hard to achieve that vision. So that was his vision. So we all follow with Mahatma Gandhi ji's path. Do it. All the very best. Good luck, friends.